Okay. So, all refreshed with coffee, ready to go? Good. So with this, will be the last formal presentation. The rest of the day is really open for discussions and your presentations. So I hope that after lunch you'll grab the floor and take action, and then I will be listening and giving comments if needed, but it will be mostly in your hands here. Here, this presentation is still to follow, to share with you what do you do with the results. As I said yesterday, you can write a good concept about a proposal, you write a good proposal, you convince an evaluator. Hopefully they actually negotiate a good contract with you. But what then? How do you defend your rights on what you have developed, and how can you use the results after the project? And that is not an automatic given. And I'll tell you and give you a number of examples why that is not an automatic given. Secondly, as I explained yesterday, the European Commission is funding, any funding agency funds you because they want to get something out that is bigger than just a few publications. So that relates back to the original question I started out with yesterday morning. Why would they ever fund you? Is it possible? Yes, okay. Because otherwise I need to shout too hard. So going back to this original scheme that I explained yesterday is also the key to define your role as towards other stakeholders. And I will spend some time in this presentation on stakeholders, especially industrial stakeholders, but stakeholders in general, also for social exploitation, not just commercial exploitation. And how do you defend your rights and your role, and make sure that you can continue with the next project with the same knowledge and build something bigger. Remember the examples I gave yesterday? All started out with very small initial projects, but they build on, like building blocks, on top of each other, and each time they add something new, so that in the end, you build something bigger, something great. Just like a house. You start with the first foundation and the small bricks in the back, and then you put on and slowly build until you put the roof. If you have the vision of how to build that house, then you can start small and take the next steps in a certain direction, instead of just chasing money for finding funding agencies with an open goal. And this is a really important thing, because I've seen this too many times. Scientists sitting on their bench with a research ID, they look in the internet, they see a funding call, and they chase that funding call. Next month, there's another funding call in a different direction. Because the money is there, they apply for a proposal there. Next year, yet in another direction. And there's no strategy, no consistency, and that is like a heap of loose bricks, but not a house. So build in a framework. And if you do that, then it's far easier to convince evaluators why you're asking their money, because they invest as part of a larger structure in the longer term. Now, coming out of education, the value coming out there is intellectual value. Intellectual value that you can pass on to the next generation scientists and the next generation leaders. They actually may work in economic environments or in governments with the intellectual value you transfer to them. Intellectual value can also reach social value in research. You add solutions for social problems, right? And social problems include health, hunger, poverty, those kind of things you can attack with solutions based on research. However, you also need innovation to implement economical value. So it's a balance. Every player has their own role. And there are lots of interactions there. Right? You have research helping with new ideas to improve education. Skilled people are educated and help to do better research. knowledge and concepts are improving innovation, not just in materials and products, but also in processes and services. You can actually innovate society based on people's learning. And that is broader than you think, because people's learning is not just from, okay, this is the textbook, this is how we do things in the past, but it's to capacitate in the learning to people to think for themselves independently and, if needed, out of the box. Real education, higher education, is to learn people to think independently, critically, to think out of the box, and that is essential to do innovation. If you can't think out of the box, you cannot innovate. So value coming out of education programs can be monitored in this way as well. You can report. And if you have a research project, together with an education project and training, part of the value is not just publications of the research, but also the value in educating people, transferring knowledge, right? And then, of course, everybody works in a framework that is bigger than their own institute. Academia has to build an understanding and exchange with industry to innovate economically. That's one. But the industry members are under constraints because they need money, not just public money. You cannot build a company with public money alone. So they need to talk and convey their concepts to investors. And the investors want to earn money. They're not interested in the product. And on the European Venture Contest, which is a program to help entrepreneurs to better defend their business case to investors in Europe. And over again, I see entrepreneurs presenting their business case, focusing on their product and how they're going to conquer the market alone. They're not focusing on why an investor should invest in their company and how much the investor is going to gain from it. What is the return on investment for the investor? The investor usually only wants to know two things, or three. How much money do you need to do what you want to do? How much money do I earn when you pay me back? And what is the risk in between? And that's importantly related to the people and the management. If you have a good management team that can lower the risk and steer the ship around obstacles, then you have a better chance of success. The same is true for a research project. So there is more overlap here than you think. So the industry partners have to defend their plans to their investors, and that is the reason why they're thinking commercially. If you understand that, where they're coming from, then it's easier to negotiate a contract with them, because you understand why they want to collaborate with you and what they want to get out, and why they're so nervous and impatient. They cannot wait for 5 years until you finish your research project, because their investors are pounding on their back to pay them earlier. See, that is the reason why there is a cultural gap between academia and industry. The expectations and the dynamics are very different. And then, above all, the whole playing ground is fenced about by the government regulations. If you're working in biotech and clinical, you need clinical approval, regulatory approval to do studies, to do research in patients. If you're working with genetically modified plants, you need approval in order to sell them and plant them in the fields. So the government set the rules, also legal and fiscal rules, that constrain what you can do. So sometimes you have to be aware of those restrictions too. And if they are too restrictive for research, you have to educate the politicians to make changes in the rules. That's a very long-term thing. But if you understand who does what in that field, it's easier to explain to politicians than if you come with a research story that they're not interested in at all. So it's, again, how you communicate to the different stakeholders that is important, also in your reports. Again, the example of the journalist. The journalist will walk away if you talk about the technology. But if you talk about solutions for society, the journalist will be interested. So that's returning again on the perception of value. A government official will perceive the value of a research project very differently from you as a researcher. And an industrialist will perceive the value in the research project in a very different angle than you in a research community. So why collaborate? Well, the answer can be here. For the entrepreneur, this is an additional reason. Because for an entrepreneur, doing research is risk. For you, it's your everyday life, but for an entrepreneur, doing research is risk. Now, if they can obtain knowledge with public funding from you, it's lowering their risk. It's a very important argument for you to collaborate with industry. No?
Just one more, that's very on.
Yes.
Tomorrow we're bringing together several of these sector partners to discuss exactly some of these issues as a follow-up but not continuation to these 2 days of workshops.
Sure.
Because we're very well aware that we need to have common understanding among government, industry, academia, and the donor community about how research and development actually works and how it can benefit each sector in this partnership.
Yeah, and it's not easy. There are a lot of misunderstandings there.
Yeah, right.
For the companies, it's not only getting access to new knowledge and getting access to infrastructure they don't have. That's also true for you. I mean, if you want to do genetic analysis, you cannot do here in Jamaica. Partnering with the European partner may allow you to do those genetic analysis. You can't do it yourself. But for companies, there's an additional reason to really invest in research. Invest, innovate, and internationalize are keywords for a company to grow. No company can grow unless they do some of this, or maybe even more. And many small, medium enterprises are struggling with this. They have a too limited view of their market, of their products, of their sales, of their innovation, and they limit themselves because they just are scared to work alone. Now, if you can help them to get access to new projects, new materials, new products, or maybe as an introduction through your academic partners into European markets, that's a way to internationalize in a much more safe manner than if they would have to do that alone. So that is an additional argument for you that you can offer enterprises with. Help them to solve their part of the problem and get out of the isolation. Why am I spending so much time on these elements? Because if you understand these principles, it's far easier to negotiate contracts meaningfully and write good reports to the funding agency for what have you actually achieved in the project. And that last one is a very tangible thing. For any research project, even without enterprises, you have to demonstrate what you have achieved. So how do you do that? Within the project or in the group, the value elements are, for example, these. And of course you can make the list longer, but this is just to give you an idea. What kind of things are value elements that you can demonstrate you have built up? At the institutional external level, you have other additional value elements, because if you work in partnership, you get access to international networks. Perhaps if you have something that is commercializable, you can get access to incubators and science parks if you don't have them here, or partners in those. Public-private partner collaborations are possible in the longer term. You do a small research project to build trust, and that can be the basis for a longer-term program with a longer-term perspectives. Inter-university collaborations reach critical mass, and of course the simple consultancy. If you know an industry through a research project, next time they might ask you for a contract research, and that's very real money that can come in. Of course, you can also get external visibility through projects like the DB4AC. Now, all of a sudden, we all know that Jamaica has this capacity, and also the people in Cameroon and South Africa learn what capacity you have here. So that things like that are all value elements. And these should be reported in your final reports also. Metrics are the usual ones, publications and patents, but also numbers of student training, number of courses given, new materials or databases obtained or developed, and the level of international collaboration. Not just I visit you and we drink coffee together, but we actually work together and did something unique that was not possible before. I think I've covered most of these elements, so this is more of a reminder.
I'm going to read reminders.
This one?
Perhaps because I missed some of the discussion.
Yeah, for the management, is really this one that we discussed yesterday. No? Managing the people is more important than managing publications and papers, and managing risk versus value. We discussed this at the last presentation yesterday.
It was nice summary.
Little checklist. As I said yesterday, in the chapter 2, management chapter, all of those we discussed yesterday, but there's a special subchapter where you should describe how you communicate about the product and how you exploit and manage your knowledge. So some of the slides that will follow give you some recommendations how to do that. This you can read yourself. What is not in the papers is how to negotiate contracts. And I would like to spend a few minutes on tips on negotiation of contracts, first with the funding agency and second with your partners. Those are two different types of contracts. Let's first look at the contract with the funding agency. In this case, an example from the European Commission. The contract called grant agreement. They change these names every once in a while. You can download from this internet address. So the contracts templates are there, and you can discuss with your legal counsel whether there are any clauses that are not some sea breeze here. You can discuss this upfront with your legal counsel, whether they identify some unknown clauses, whether they miss some clauses, whether they see something that is interpreted differently in your local law. So please have a discussion up front before you start negotiating, so that the legal counsel is not surprised by all of a sudden there's a contract and next morning it needs to be signed. But that's not the way to start a negotiation. The structure of the thing, I tell you, because several different people need to have a look at that contract. First of all, if you get the invitation letter for entering in the negotiation, you have just the text of your proposal. And you need to convert that text into a text that is a part of the contract. The Annex 1 is called the technical annex that describes the technical work that you promised to do in the project. So you convert the proposal full text, and you eliminate partner descriptions and things that have no legal meaning, and just focus on the delivery, the milestones, the planning, the roles and responsibilities in the budget. That whole text goes into, is converted into a technical annex to the contract. During that work, which takes a few weeks, you can still make modifications. So if by the time you wrote your proposal, you thought that you could do a certain task in 2 months, and you realize now, so many months later, that you need more time, you can still change things. You cannot change the scope or the core of the project, because that was evaluated by the evaluator, and the funding agency would never accept that you change completely. But small things, well justified, you can still change. And it's worth to have a look at, because there are several months in between. You have gained experience, maybe there's a change in staff, maybe your funding rates are slightly different, your financial rates are slightly different. There are things that change in a few months. And as I said yesterday, the deliverable list is something that you will be judged upon at the end in the final reporting. So have a second look at the deliverable list and the description of the deliverables, and make sure that you can actually deliver those precisely according to contract. The second annex is the more legal part of the contract, where you promise to deliver, the funding agency promised to pay under certain conditions, and where you describe how the intellectual property will be dealt with. That means the general principles between the Commission as funder and you as a consortium. Now, these usually are standard conditions because the European Commission does not impose very much restrictions there. Contrary to NIH, for example, where, I don't know about the most recent contracts, but in the past it was always this little line: if you build something valuable, develop something valuable, and you want to manufacture, the manufacturing has to be in America, because it's American taxpayers' money. Now, that kind of restriction does not exist in Europe. If you develop something valuable, you're perfectly fine to manufacture here. As at the same time you develop some benefit for Europe, then everybody is happy. That is the basic, the non-technical explanation of the clause. I will explain in a minute where the restrictions are. They're in a different part, but not at the level of the European Commission. And the grant agreement itself is just 2 pages. It says only, this is the funder, this is the consortium, starting date, end date of the project, and the budget will be so much. Not more than that. And signature pages. So all the details are in these annexes. And please have a look at this together with your financial people and legal counsel to make sure that they're happy with this, because your director needs to sign on this. And some guidance you can find on these documents, which you all find on this website. So this is the fairly straightforward, easy part. The difficult part is in the contract that you sign between the consortium partners, because the overall framework of the Commission is, this is the playing ground, we pay and you do your thing. But who does what within the consortium? Who is responsible for what task in the consortium? And are all members equal, or are some members more equal than others? That is what you agree here in the consortium agreement. Unfortunately, there are model agreements, and you can find them here. And I can give you much more detail if needed, but suffice to say now that there are mainly 3 model agreements there. I did not write it on the slides, but the DESCA agreement is the model agreement that is probably most appropriate for you, because it is focused on academic institutes primarily, who also work with industry if needed. The other model agreements are more for industry or for very specific ICT environments. So DESCA is D-E-S-C-A. These model agreements have been constructed in consensus among many, many big players all across Europe, including academia, industry, and some very good specialists of large institutes. So you don't have to reinvent the wheel. However, please be aware of that they're rather complex to read. So you really need legal advice to make choices on option A or B in these model agreements. They discuss the technical roles and responsibilities of each of the members, the management principles, the voting principles that are applied. For example, you vote by majority vote, or is there any industry member who demands a veto, or an academic member who wants to have a veto if certain measures are taken. Financial provisions, how is the coordinator to pay you? They give everything up front, or they pay you only after delivery of reports, which is usually the case. That is something that has nothing to do with the European Commission, but it's something you negotiate with your coordinator. And it's good practice to have a look at this up front. If before you start the negotiation, because then at least you know where the pain points are, where the difficult areas are, and then you're prepared to prepare a good answer. Again, it depends on your role, whether you're full partner or a subcontractor or third party. It applies to how you have access to the knowledge, and that will be shown in the next couple of slides. Access to knowledge and ownership of knowledge is very important to know and realize before you start negotiating. Because some issues may not be important for you and others may be very, very crucial. And some of these elements I will discuss in the next couple of slides. And usually confidentiality, ownership, and access rights. Those are the 3 that are most difficult to negotiate. Most people think of negotiations like this, like the bossy type. I want to get the most out of this negotiation. I want to pull your leg. Well, maybe not, because you can do that once, and next time you have an enemy, and you will never have a partner. And it's not a good start with the start of a project. So how do you do this in practice and create the so-called win-win situation? Everybody talking about it, but how do you do this in practice? It's not the bossy type. Why do you need to negotiate? Well, to avoid this. Because contracts are to avoid this situation. If you don't negotiate, you leave everything free, then if there's a conflict, it will be like this. Really a mess. So unfortunately, negotiations and contracts are necessary. And it's much better to do this up front before you start the project, make good agreements in peace. Because if there's a conflict, then people are much more rigid and they don't negotiate anymore. They just want to defend their position. Now, a couple of basic things. And again, I'm not a lawyer, but in my business development department, I've set up an IP department. We had lawyers in my group, and I learned a lot in practice, although I don't have a formal legal degree. And that's why I try to discuss things in non-legal terms, so that scientists and you as coordinators and managers can start asking the questions to the real legal experts. Background information or knowledge is really something that you have already before you start a project. For example, you do an ICT project, you have a database, you have a certain piece of software, and you start working with another partner who would like to get access to that knowledge to do joint research. Now that is background. This background you bring into the project and you allow your partners to work with it. You may even charge a fee for certain things, but usually it's for free because you want to do research together. Foreground are the results that you develop together. Now this is important because the background is what you own already, and of course you keep that ownership unless you give it away for free. But foreground is something that you develop together, so by default it's jointly owned. If you do research together with your partner, you both put your knowledge and capacity and expertise together, develop something new, then both are owned. Now this is complex because in a larger project with 10 partners, not everybody is involved in all the tasks. So if two partners develop a new material, an antibody or a drug, do all the other 8 partners automatically own that drug? Well, maybe not. That is why a contract agreement is so important. They may get access to the drug to do research, but they may not have automatically the right to sell. Those are two different things. So please make the distinction between background and foreground. And a good practice is to distinguish between ownership and access rights. Ownership is what you have developed yourself or you bought. Access rights is where you have access to use for specific purposes, either for research or for commercial purposes, but you don't own, so you cannot give it away to somebody else. Only the owner can give it away to somebody else. Now, during the project, you have certain rights. For carrying out the project, you should have the right to have access for research purposes. That's normal, as a given. But the big question is, will you have still access rights to what is being developed in the project or the background of other partners after the project? After the project, if somebody has these fantastic antibodies in the freezer and the project is over, you have no relationship with that university anymore, can you still have access to those antibodies to do other research? Not automatically, unless you agree in the consortium agreement that for the purpose of this project, plus for the future, you may have access to those antibodies. But it's something you have to ask. It's not given automatically. And the same for industry. Industry may not have access to all the results of the project unless they negotiate upfront that they are responsible for exploiting and commercialization and may make money with the results. But you, as an academic institute, have to allow them to do that. So please keep that in mind, those 4 elements. Background knowledge you bring into the project, foreground you develop yourself inside the project, which is new. Access rights during and after the project versus ownership. Now, there are a couple of little things that I just wanted to point out. One is that transfer of ownership is possible by the European Commission. They allow whatever you like, whatever is needed to carry out the project. So the Commission will not bar you from transferring, but your partners may bar you from transferring knowledge. If you jointly own something, a new antibody or a new plant or a new process, and one of the two owners transfers to a third party, they may have to ask permission to the second owner. Also, that is part of the consortium agreement. On the contrary, what is new in the last few years, that even in public grants, with public payers' money, it's now allowed to transfer results, commercializable results, exclusively to one partner. That's possible. In the past, that was not possible, and still some funders have restrictions in this field. Now, this is very important if you have two industry partners in a project. Who gets the exclusivity? Ideally, they have a different market, and they get exclusivity for each for their own market. That's ideal. And you have also the situation where you have one industry partner who gets exclusive rights for everything, and then all of a sudden, after the project, there is another partner, one of the partners gets another industry who also wants to have access. And then you have a triangle. The original owners, academic institutes, transfer to this first industry partner exclusive rights, and the next industry partner has to negotiate with both to get part of access rights for another market, for example. So those are the complex situations that may arise. And just think of these in scenarios. What if, while you're preparing, you may grant exclusive rights for certain markets to one industry partner, while capturing the right to transfer your knowledge to another industry partner in the future for other markets. That way you still keep control over your knowledge. You are sure that the first industry partner actually uses the knowledge and you get some financial return. But if there is a better contract in the future that is not competitive with the first one, you're still allowed to do that. If you sign away all your rights to the industry partner, they have full control and they don't bother to pay you back, and they can control the full exploitation everywhere, and you limit your return. This is another one to be aware of if you're working with multinational companies. Say Monsanto has a small office here in Kingston, they want to be partner in a project. You transfer rights to Monsanto for certain seeds, and they can actually use those seeds and sell. If you don't specify who exactly has access to those seeds, then automatically the entire Monsanto worldwide will have access to your seeds. That's a very different situation than if you transfer to Monsanto, Kingston, Jamaica only. So please don't transfer everything without restrictions. Be specific how you transfer. For which market, for which projects, for how long, and how much money do you get back. Those are the four elements in it. And one small advice, people think of patents and royalties if you talk about license fees. But there's far more to it. Especially in the biotech field, if you transfer a license to a patent to an industry partner, the time that they need to bring a product to the patient in the market and start making money is so many years that you may never see your royalties. So you may be very happy to have on paper 20% royalties and say, wow, but you may have to wait 10, 12 years for this, and by that time so many negotiations have deteriorated the contract, and then you end up with nothing. That is a real risk. So it's more intelligent to negotiate a mixed deal where you say, okay, for the first few years, we want to have milestone payments. If you achieve clinical trials and you are allowed to sell, then we want a certain payment. No, royalty is just a fixed payment. If you achieve a certain level of marketing sales, let's say they make the first 50 million euro on a drug. Now you can negotiate on those conditions, we start paying royalties. If you make much more than that, we start making more royalties. So that way, it's a more balanced deal. It's a small tip, but this can be used in many, many instances. business, and sometimes it's more intelligent to negotiate upfront payments that are fixed instead of royalties, because it's more secure for you, and for the industry partner, they're free to negotiate other royalties without having to pay you in the long term. So usually that is a better basis. Payments for milestones can be in terms of actual money or in terms of investment in your facilities. You can let them pay your staff or equipment. There are all kinds of ways to transfer revenue back to you.
Wanted to ask, what kinds of technical competences would be required here? The more we go through the workshop, the more we recognize that the research and innovation manager is almost godlike.
It's a double does all, yes. It's very difficult to have all skills in one person.
IP lawyers here.
You need a team.
What do you need?
Eventually you need a team. But that doesn't happen overnight. So, as a general remark, I see most universities, institutes starting with a person who has certain business development and above all communication skills, who knows how to tease out information from people and transfer it to others.
So someone with business
secondly,
skills.
somebody who asks the right questions and find the experts externally. Like patent attorneys, you don't need internally. Initially, work with an external expert, but have somebody in-house who asking the right questions and then transfers, if needed, to an external expert. That's what I would do. And thirdly, maybe project managers, really to help scientists to be proficient and efficient in the reporting and the progress of projects.
So the team is getting bigger and more complex.
Yeah. Sorry. Sorry. But that, I mean, if you have more projects, you also have more funds to play with and build that team. As I said, anybody directly related to research can be part of the project. So a business development manager can be part of a research project. There's nothing wrong with that.
Okay.
A small slide, non-technical, just to realize the process of disclosure of knowledge to patent filing. I mean, as I said, intellectual property is much more than patent filing, but in the case of patent filing, there are certain procedures that you need to follow, otherwise you have no patent. And one of them is initial disclosure in a formal form. So you record, if somebody has something that is potentially possible to protect with a patent, you need some kind of formal record that this invention was invented by this person at this moment in time. Why is that important? Because in the patent application process there will be an investigation whether you were the first to invent this or not. And there may be other institutes who also have similar ideas, and that in internal, first formal disclosure form demonstrates I was on this day the first to discover this idea and invention. But it may have legal consequences later. It's a simple thing, a simple form, but it needs to be demonstrated and time recorded and signed. That's the only thing that is needed. So it's a good way, if you're in technical engineering fields, in agriculture fields, medical biotechnology fields, especially in engineering, it might be a good idea to set up an internal disclosure process.
Yes.
Very simple thing.
It's not a minor matter at all, it's a significant and major matter. Laboratory and research records tend sometimes to be pretty patchy and not very specific about what and when. Yep. This matter of noticing with precision and having the disclosure done is going to be crucial for any external demonstration of an IP rights.
It also relates to another assessment which I will discuss in another slide here about the quality that you develop. If you work with industry, they want to have consistent quality. So it means that you have to sort of record in your institute how you produce something, so that you can reproduce it in the same way next time. That's important if for example, if you have an engineer who is developing a certain material, a biological or chemical material in the institute, and after 3-5 years that engineer leaves. If you don't have a record exactly how he or she did it, then you cannot reproduce that knowledge and that same material under the same conditions. And that's very important if you work with industry partners who want to have samples of exactly the same composition over the years. So simple things like that are related to quality of management procedures inside. It's nothing to do with public funding, but they're quite important when you deal with partners in the longer time frame. Well, these questions are self-explanatory. This goes a little bit too deep, probably, for the audience now, but this is a reference, and if you want to have more questions, we can talk about patents, no problem. There is fortunately also additional help free available. IPR help desk, similar to the finance help desk, there's an IPR help desk in Europe, and you can also ask questions to them. You don't need to be European. Even if you don't have a European project, you can still ask questions there. You get answers in 3-4 working days in 6 languages. So you can ask a question in Portuguese if you want. What is equally important, there's again this RSS feed, and so getting alerts on new announcements, and they have a newsletter which you can describe freely, which has technical background, advice, good, nice case studies, but also announcements of funding calls. So this is another way to find whether there's a new funding call announced in Europe. And they also organize training workshops on intellectual property and commercialization and things like that from a legal perspective. They're not business developers like me, but they're legal experts. Yeah. They will not defend you in court, but they will give you templates and models and tips on negotiation, how to defend your rights. It's free advice, so please use it. There's another one, the website, the Landmark Agreements, and since you're part of the Commonwealth, you probably know these. Certainly your legal counsel should know this. And that is a website where from the Innovation Department in the UK, a number under the numbered treaty, a number of agreements, model agreements and templates have been constructed that are agreed to work under Commonwealth law. Please be aware that Commonwealth law or case law is very different from the Napoleonic code we have in Europe. On the continent in Europe, we all have the pleasure of working under Napoleon 200 years ago, and he imposed a unified constitutional law. Really a very different base of law than the case law that you have in the Commonwealth. You will see that reflected in the contracts. If your legal counsel is asking for, I don't understand this contract, maybe it's because it was according to Belgian or French law. European law follows Belgian law. It's a small thing. Going back to the Lambert agreements, this particular website is very nice because we also have the simple templates like a confidentiality agreement or non-disclosure agreement, whatever you want to call it. Material transfer agreements, small unilateral partnership agreements, things like that. So not just the big agreements, but also the very small practical things you can find here. And this one is particularly interesting for the next couple of slides, how to partner with industry. I was one of the authors of the first version of this guide. Now there's the second version of the guide, which is part of the package. But it's a handbook with lots of guidelines. What is the best way to position yourself in negotiations? Very valuable stuff to read. So I can highly recommend that. Please realize that transfer of knowledge is far more than just licensing patents. All of these are ways of transferring knowledge. And it doesn't matter how you transfer knowledge, as long as you keep this in mind. What is your mission? What are your resources and the expertise you have in-house? Defending your role versus the role of your partner. This is a deep one. If you think about it, it really is a deep one. Because you may want to develop a drug or a product all the way to the market, but is that part of your mission as a research institute? Probably not. If you want to sell products, that's a commercial activity. That's not part of your mission either. Maybe in that case, it's better to set up a spin-off or a joint venture. So and the expertise and resources you have in-house may demand you to set up a different structure to focus commercial adventure. Or to transfer to a more experienced industrial partner if you don't have the capacity in-house, obviously. This we sort of briefly touched on, but this is also important. Please realize that your partner may not be experienced in all fields. Also industry partners, especially SMEs, may not have experience with all these tasks. And they may be novice in the negotiations too. This we discussed already. This we discussed. This is a little thing that I touched upon earlier. Lab records. Lab records about how you produce a certain piece of material or product are very important for not only for patent but also for quality control, so that you build something consistently. Especially in the biotech pharma, this is extremely difficult. I wrote this because of a case where we worked with a pharma company and an academic institute, and the academic institute changed the way they produced their drug. And then during the clinical trials even, the pharma company wanted to go back to the original sample because they suspected that something was different. And yes, indeed, they found that one of the technicians had changed the ingredients and changed the protocol without telling anybody else. The whole clinical trial, worth 25 million euros, had to be redone. Now, who was bad here? So keeping records is a responsibility. It's not just a nice to have. Of course, it depends. In social science, this may not be so relevant, but in certain biological and chemical departments, it's really relevant. The other thing is confidentiality issues. Most people think of confidentiality agreements and issues in relation to industry contracts, but it's far more wide than that. In academic institutes, you have the issue, for example, take the situation you have as a PhD student, they discover something new, they do the last experiment on Friday evening, and then on Saturday they see the results and they say, wow, this is fantastic. There's a conference where I can present this. So, deadline to present the abstract, Sunday evening. So they type in their abstract, send it off. On Monday, as a group leader, you discover that they have sent in an abstract of results that should be kept confidential. No way you can control this, except if you teach your students right up front, first have permission before you tell anybody else. And abstracts are publications. They're public disclosures. So be careful with that, please. The same with temporary staff. I mean, they have not a contract with you normally. Now, I remember, you may remember that I discussed the issue last October as well. It's really relevant working with temporary staff who come in and out, same like students, have done some kind of contract to sign so that they promise to keep things that are confidential, that they do keep it confidential, that they do not take materials with them, and that you have no control anymore what happens with those materials. Suppose you have a very valuable piece of equipment or a very valuable product in your freezer. They walk away, give it out to a third party who does some fantastic experiments. You're not even author of those publications because you don't know about them. Maybe they reproduce, copy it, and then they start selling the product. You have no control over it. So include two elements at least, or three rather, in any simple contract with temporary staff or students. Who bears responsibility? You. You need to give permission for some certain things. Confidentiality issues and material ownership, transfer issues. Don't walk away with my material without my permission. Very simple things, but this is actual academic level. So that's what I said. And you need some policy for this, really. You need a policy in-house to control this, because otherwise you will sooner or later be in trouble. And creating awareness with staff, with examples like this, are a very good way to not to make it very formal and heavy, but still have them motivated that they abide by the rules. A little checklist again to share with you. In academia, industry, cooperation, communication is the most crucial one, just like with many management issues. Meaningful communication and communicating ideas without assuming that the other one immediately understands what you mean.
Yeah.
Industry talks different language than academia. It's a cliche, but it's true. I work with both, so I think I can say this. The differences in management culture, different timelines. Industry usually thinks in days, while academia thinks in years. And this is not a cliche. Unfortunately, it's true. So manage expectations there. Don't overpromise without specifying. I can do this research, but for this and this reason, I need a year to do this. And they don't come next week for the results. But in the meantime, keep a good communication line built. Tell them about your progress. Tell them about how you're proceeding, so that they have the right expectations, also in terms of money, payments, and percentages of time. Lack of insight of business development in academia is a general thing. You see that everywhere, also in Europe. Really, sometimes you see business development departments, 3, 4, 10 people, all led by academics who have never even been in industry at all. That may be a problem. You should have at least one person in there who has spent some time in industry so that they can relate to the cultural differences and get some sense of reality. Insufficient capacity to deliver. I mean, you would like to do this fantastic project with 10 million euro. And there is 10 million euro available from your partner, but can you deliver? Even if you have 10 million euro, it takes time to build up the expertise, to hire the people, build the buildings, etc. So be realistic there in how you build up that capacity. And then, as we said yesterday, signing contracts, infrastructure, organizational restraints. And then, of course, there are financial differences, international differences in financial systems, legal systems. Americans tend to be very, very strict in their contracts. So the contracts are super important, and they don't take one step before the contract is signed. Well, in Europe, there's a much more relaxed atmosphere where, yes, contracts are very important, but still you can do things before the contract is signed. There's much more a trust basis than in America that way. And that is a real difference, I find. I'll skip this one, except that just point out again your contingency plan B. Please don't forget it, because things can go wrong. And if you don't have a plan for that, then it might be difficult. Just 3, 4 examples of misconceptions that you find everywhere, also in Europe. Many universities are working out with these ideas. On the one extreme, universities should not patent. We're public institutions. We're doing basic research. We have nothing to do with industry. You can do both. You should not abandon your role for fundamental research and still can transfer that knowledge to the industry and let them do their thing. If you don't patent, the industry will never, or protect your knowledge better, the industry will not be able to send their product on the market. So you help them. You're not going to commercialize, they're going to commercialize. If their rights are not protected, they will not be interested.
Yeah. Actually,
so this is one extreme, yes?
The legal situation with UTech in particular tends to encourage that misconception, because it is a government-funded institution which is still governed by the education code, which governs secondary schools and colleges and so on. And there is at the moment a significant legal issue about, can we do the other things which universities do, such as own knowledge in our own right, and therefore patent and sell and so on. Or is it income for the consolidated fund of the government of Jamaica?
Mm-hmm. Or is it rather the industrial partner who pays?
Yeah. Well, if it is an industrial partner, but the case
is quite possible.
If
you have an industry partner, then you can ask them to pay for the patent protection, as long as you allow them to do that.
Mm.
That's fine. It doesn't necessarily mean that you have to pay everything up front.
Okay.
The other extreme is equally naive, I would say, that if you generate intellectual property, it should always be protected by the patent farmer. Well, maybe not. not everything is protected by patents. For example, databases and software may or may not be patented in the US, but certainly not in Europe. You cannot get a patent on software. You can get a patent on hardware applications with a software component, but not on software itself. So there are legal differences between Europe and the US. And let's take the other example. If Coca-Cola, 100-something years ago, would have taken a patent on their recipe, they would have gotten 20 years of experience, protection, and then they would have been out of business because Pepsi and any other would have copied them immediately. And then there would not be Coca-Cola right now. So they kept the thing safe and secret in a safe. There's only 1 or 2 people in Coca-Cola who know the complete recipe. Everybody else knows bits and pieces. And they're still in business. Now their intellectual property is not just the recipe. Their biggest value is their mark, their copyright, their brand name. That's far more valuable than the recipe. So intellectual property protection is far more than just patents. Huh? Please be aware of that. And it can be cheaper too, if you can keep something secret, or if you can apply only for copyrights instead of the actual patent. That's a completely different financial situation. This is another one. Universities cannot cooperate with industry because they have different objectives. I would turn it around. Yes, they have different objectives. In spite of that, they can cooperate because they're complementary. Like man and wife in a marriage. They're very different. No, they can still have a good marriage. So, to me, this is rubbish. I mean, there are difficulties, that's something else. But not every marriage is easy. But they can be very valuable. And then all to take patents to earn licensing income, well, this is clear rubbish. The AUTM study, that is the Technology Transfer Association in the US, has done a study a number of years ago already with Caltech, Harvard, MIT, and several other top institutes, and they calculated how much money do you earn with patents. And besides for the 1 or 2 really big deals, but one license gaining 150 million euro or so, by average, all the patents were barely, all the license revenue were barely covering the administrative costs. So they're not making money on licenses. They cover some of the expenses to transfer, but it's not a money maker. So this is really not a message you should give to your executive management and council. Well, let's license so we have an additional income stream. No, the real value is to partner with industry who can then pay your infrastructure or your personnel. You get access to new research money from public funds. You can maybe create jobs by spin-off companies. There are lots of other value elements that I gave you in the previous presentation. It's not the royalty licensing income that makes a difference. I'll skip this one, I can explain if you later. So if you want to protect your rights and think about an exploitation plan, this is the very first question you should ask yourself. And it's a very difficult question. You have something new knowledge, new product, new materials, new process. Who can benefit from it? Where is your market? Is it here in Jamaica? Is it in the Caribbean? Is it in Europe? Maybe Europe and the Caribbean and the US, or maybe Africa. What is the business case? How do you make money with it? Or not you, but your industry partner. How do you make money with it? Take the example of software. If you sell software, you can have a licensing income. Every single user pays the license fee and you make an income. But you can also do, there's a different case of business model, you give away the software for free. But if you want to have upgrades for special applications, then you charge. Or, like Skype, they give the software for free, they use for free. But if you want to have special video conferencing facility, or you want to buy goodies or like telephones through their service, they make money on that. Like Ryanair, they sell the flight tickets for almost nothing. But they make money on the seats, on the access of baggage, on the coffee they sell, and now they're thinking even to charge for the toilet seats. It's crazy. That is their business model. They charge nothing for the flight, they charge for everything else. And they make a lot of money. So the business case and the model really depends on where the value is. And that determines how you protect and where you protect. There's no use in protecting a patent only in Jamaica if your market is in Europe. It may be cheaper, but we make no money that way. So this is really the core question that you should ask yourself before you start protecting and negotiating grants. And then, as I said, sometimes you need to be aware of manufacturing clauses that may restrict or changes in ownership. And well, this is an interesting one we can discuss in the afternoon. But in Sweden, Germany, and Spain, there have been some changes in legal ownership of whether the inventor owns or the institution owns. We can discuss it in the afternoon. Because of time, I'd like to go to the last maybe 8 or 9 slides. One slide with recommendations. Again, don't focus just on the tech transfer, short-term returns and license fees, but focus on the value of the many stakeholders. And that is more difficult, more complex, but in the end, you make your case much more strong to the different stakeholders and you gain more, creating a socio-economic impact instead of just on the license fee alone. Summary slide here. I think I gave you many examples of successful industry partnerships. How you can build value together with each different role, like man and wife in a marriage. You have different views on life and different skills and assets. So be complementary in what you do. Demonstrate your track record with external funding because that gives you credibility. Also, industry partners are usually very keen on working with institutes who have a track record of external competitive public funding because your proposals have been evaluated at the external peer reviewers and they have like a quality stamp on it. So that is a selling argument for you, for industry partners too. I got a European grant or I got an NIH grant. That gives you a certain level of credibility, really. Track record with working with industry as well, showing and demonstrating that you've done already deals with industry or contract research, albeit very small, can give you the confidence to go to a bigger player next time and say, okay, this is how we have this experience, we know how to do the process, let's take the next step. And for that, these guidelines are quite useful. Regarding the business case and the market, there's an additional element. What I see quite often, especially with engineers, they have something developed and they think this is going to change the world. Everybody will be waiting for my innovation. Well, it depends on whether the market is ready. And you can be not only too late, if somebody else is quicker than you, then you lose your market, as I said yesterday, but you can also be too early. Look at King Richard here in the Middle Ages, and getting this fantastic solution from this engineer, and he's not interested because he has an immediate problem now. He doesn't even recognize that this is a solution to his problem. So you can be too early, too advanced in the market. There's a time window for innovations. And you can find some crazy early adopters who may test 1 or 2 because it's new. But the real market is usually with a big group of followers who adopt a technology or a product in a large scale, and that's where you make the money. You see all big companies making money with large markets, and those are not the early adopters who adopt something because it's new and exciting. That is just a very small group. Now, the second element in this slide is the time. The moment that you have this bright idea, you convert it from the lab into a technical prototype that with nuts and bolts and wires and things that hangs around, but it works in the laboratory in the hands of the engineer. It may not be sufficient to send out to any consumer. Like if you see the very first examples of a television, it didn't even look like the televisions we have now. It was not a consumer product. And in the biotech field, this is very, very relevant because the very first products may not be the products that are allowed on the market. You need to prove that you can cure the patients, that they're safe and they're effective. And that may change your medical drug candidate into a real medical drug that is accepted. Quite often, what I said yesterday, you have something that works in the laboratory in a petri dish. It kills the bug in the laboratory, and then you test it out in animals, and all of a sudden you find that the animals have no effect, or it kills the animals. It kills the bug, but also the animal. Not very nice. Or worse, we had this huge chemical screening on a very large library of chemical compounds, and then we found a very effective compound killing all HIV viruses immediately, the dream compound. And then we started to do animal studies and all that, and it was fine, fantastic. It worked, and we tried to develop a dossier for the first clinical studies in patients. And then we started to talk to one of the medical doctors, and he said, this will never work. Why? Oh, he says, no, it passes through the kidney and you pee it out immediately. And yes, we did a test with 3 patients, and indeed, 99% was immediately lost. So we had to go back to the laboratory, redesign the chemical molecules so that it stayed in the body before we started doing patient studies. So I gave yesterday another example about drug delivery in Africa. So going back and forth between prototypes and what works is very different. And then, of course, you have the phase of design. How you design something to make it attractive for consumers to buy. Like the software that nobody can understand. And you put a layer of interface on top that is very simple to operate, and then all of a sudden you have a product that sells like fantastic. And then you have the upscaling problem. Industrializing, you can make 1 copy, but can you also make 100,000 copies? That's a very different process. If you think of fermenters, for example, you can have a fermentation in a small bottle. If you want to do the same fermentation in the 10,000 liter vessel, you have mixing problems, you have temperature gradients, you have all kinds of different things, residues that are clogging pipes in the bottom, I mean technical problems that you have to solve. That also requires research. So there are many, many steps after your research idea to bring something to the market. And understanding this, the requirements of the industrial partner who does this part, can help you to do better research here too. And yeah, we need different skills here too. And this is what we help our customers with, to get the different partners in each of these steps to move this to there. Sometimes you have products and knowledge coming out here that you can use in different markets, or ideas that you can bring back to new knowledge and new research. So it's not a simple linear thing. There are lots of interactions there. And that, again, depends on how far you want to go. If you're a researcher, are you a pure research performer or a subcontractor? Are you partially user? Are you an adopter? It depends on your role, how far you can go. This we said already. I'll skip this one. Just a small reminder of what I said yesterday. In all the negotiations, this is super important. Don't have just technical stuff on the table, because you need some technical knowledge and project management, time management. These are rather hard skills. But in good negotiations and management of projects, you also need this. And sometimes you need the second person who have those skills to help the technical. I remember this, we had an engineer in our company who had this fantastic invention, and I was sitting there together with a patent attorney to write a patent about it. The patent attorney had a legal background, he couldn't understand anything that the engineer was telling him. The engineer was here, hard skills, and then I had to translate here in the negotiation presentation skills to translate the technical stuff into something that even the lawyer could understand. And it's all the way that way. And real project management has all those different skills, just like what I said in the orchestra. Everybody plays a different instrument, and only by working together you achieve something valuable. So with that, that was my last slide. And we'll go for lunch and discussions and questions, and please grill me while I'm here. for further questions and cases. And after lunch, the floor will be yours as well, so we can talk about your projects and cases. And looking forward to that.
Good.
Okay, thank you.
Lunch is ready. We can get into line quickly. Let's see what they are first today. Oh, there's another disturbance. No, investigation.
Who funded your research? Someone asked for extra assignment paper.
I'm off from now or over and out.